And I just want to clarify what I said. On this software program, when you make it full screen, it takes away the time
That's fine.
All right.
I'm not worried about the time.
Right.
I'm more worried about what's going on in the picture.
Sure,
Okay?
I get that. It's still on the video.
Start it again. Not at the beginning, just where I told you to stop.
I have to start over because the way
right.
I closed it. So
I'm making notes, see, so.
I can pause it at a particular time.
Okay. Pause. Miss Lindsay, Mr. Manley, both of you come up behind me. Mr. up behind me. Mr. Muscat, would you back that up about 3 seconds? No, I want it left or right.
I know I have to do this to back it up and then
all right.
go back
All
to
right.
full screen.
Your Honor, I hate to interrupt, but everybody in this side of the audience can see the monitor. No.
Detective Deering, cover it up when it's appropriate.
May I stand behind
Sure.
Mr. Muscat to 5 blocks?
Okay, Judge, it's a couple seconds before you told me to stop it.
Okay, go. Pause. Back it up just a couple seconds.
Nope.
I didn't hear that. No, I want it on the record. Oh, yes. Let's go off the record for a minute. It's one of those things that I had to take care of. Yes.
Oh, no.
All rise.
No, don't do that.
All rise, please. You may be seated. Thank you.
Mr. McCluskey, don't stand behind. I appreciate what you're doing, Mr. Muscat. I can see you're covering the screen. Okay, you're on the record. Okay, would you move it forward, please? Oh, I know what's going on. Okay.
Okay.
Okay, stop just a second. I have a question to ask. Counsel, in the white van is the one witness, Mr. Beal,
Correct.
who has not testified, but that's him sitting there.
Correct.
Okay, thank you. Would you play the next one?
Exhibit 9 for the record is 29 seconds. And I should note the times that we put on the list.
Okay.
It goes with these clips. The
Which
times
we
as
agree is
reported.
probably not the right
Right,
time.
the times as listed on the video.
Right. Let me see the next one, and you make the record of what it is.
It's Exhibit 10 from 5:33:35 to 5:36:25 is listed on the video.
Okay, may I see it, please?
Yep.
This looks like the same one I just
It's
saw.
a longer version of this one. They
Okay.
start at the same time as Exhibit 9.
Okay. Can we agree that to the left of the screen, close to the top, is Miss Dowdell, and that Mr. Beal has now exited the van?
Correct. Correct.
And now Miss Dowdell is walking,
Yeah, correct.
and she's about in front of... Yeah, I think I've seen what I needed to see.
All right, I added in a few seconds. Sir.
Thank you. Now, Mr. Manley, you made me feel kind of guilty because I said, push this along, this is just the probable cause, but I don't want you to rest your case if you think there's important information.
First of all, let me apologize to the court because I in no way, shape, or form took the court's
Type scenario, and in that case, the court indicated the limited function of the magistrate in weighing conflicted testimony is well stated, and they relied on a very old case, People versus Ulster, which I know the court is familiar with. It must be remembered that it is not the function of the examining magistrate to carefully weigh the evidence and discharge the accused when the evidence conflicts or raises a doubt as to his guilt. Such questions should be left for the jury. So as it relates to what's going on here, and did I give the court the cite to Buckner?
I don't know, ma'am.
Okay. Henry Buckner, 92 Mich. Act 119. And furthermore, more recently in the case of People versus Gecky, they once again indicate that it is not the function of the magistrate to resolve conflicts in the testimony. That is for the province of the ultimate trier of fact. Now, specifically, as it relates to this case, I can go through each of the charges that the court wishes me to.
The court is not going to limit your summation
Okay.
in any way, shape, or form, except I'm going to ask you not to go all day.
No, I'm not. I'm not. I'll be very brief, Judge. As it relates to the unlawful imprisonment charge that's charged, I want to point out to the court, as far as the elements are concerned, it specifically says in the criminal jury instructions the restraint does not have to exist for any particular length of time and may be related or incidental to the commission of other criminal acts. And in this case, I think maybe people were confused that when the people's position was that the actual unlawful imprisonment began. It is.
I think I looked at the evidence of what you considered. Am I right? I re-looked at it.
Okay. Yes, because it is our position that the unlawful imprisonment happened once she was in the room.
That's what
Okay.
I think I just asked to see again.
Okay,
right?
yes. So at that point in time, the plain and unambiguous, I need to take some water, Judge. I'm sorry. The plain and unambiguous language of the unlawful imprisonment statute does not require proof of the underlying felony. The language of the statute requires that the prosecutor prove that the defendant knowingly restrained another person to facilitate the commission of another felony. Facilitate means to make easier or less difficult, and that comes from People v. Wynn, found at 211 Mish App, Lexus 1679 at page 12. That is an unpublished opinion. The language does not require that the prosecutor prove that another felony was actually committed. The underlying felony in this case could be either criminal sexual conduct, assault with intent to commit criminal sexual conduct in the third degree based on force or coercion, criminal sexual conduct in the third degree based on mentally incapable due to their level of intoxication, and criminal sexual conduct second degree, force or coercion plus personal injury. The underlying felony in this case is whether he restrained her to facilitate the commission of another felony. Now, knowingly restrained, we have ample evidence on this record that the court has seen the video. Additionally, you have the complainant testifying she did in fact tell the defendant that she wanted to go home. The defendant's response was basically that he didn't care, that he wanted her. It is clear that the victim wanted to get away from the defendant and she wanted to get out of that room, and the defendant was in control of taking her back on the room on more than one occasion. It is clear, and the court saw the video, that when she got to the room of Miss Dowdell, she was trying to get into the room of Miss Dowdell away from the defendant. The defendant, when he grabbed her and pulled her back, he was restraining her. And as it relates to the commission of another felony, the court can look to the testimony. The victim indicated that she was in the room. When she got back in the room, she was on the bed. The defendant began touching her. The defendant was unclothed. The lab reports indicate that there is DNA from the defendant from the cervical swab that indicates that circumstantial evidence of penetration and a sexual act. Criminal sexual conduct, assault with intent to commit criminal sexual penetration. Basically, the elements of that crime are assault with an intent to commit a sexual act involving sexual penetration. And essentially, the court has heard the testimony as it relates to that. There was, in fact, an unconsented to touching. In this case, the court saw that the victim was not consented to be touched when she fled from the defendant. When he placed her back in the room, she indicated that he placed her on the bed, pulled her panties to the side, and what's particularly interesting in this is she indicated that she didn't feel like she had any options, and she outlined to the court why she didn't feel like she had any options. And if you take the Hale case and the Abdullah case, they are viewed from her subjective state of mind. The defendant did, in fact, have the ability to overpower her, and the court saw he did overpower her and take her back into the room. And there is ample evidence of intent to penetrate. Actually, there is evidence of actual penetration, because from the cervical swab, which is on the inside of the body, they did, in fact, find the defendant's DNA. There's circumstantial evidence that there was intent to penetrate, indicated by the victim. She said the defendant said he wanted her. He was naked. He was naked both times he came out. He never took any effort to clothe himself in that full 13-minute interlude between the first time he ran out and the second time they came out. And I should note, it doesn't take 13 minutes to put on a pair of underpants. The victim had her underpants on, but the complainant had her underpants on, but the defendant, when he came out on both occasions, had never done anything to dress herself. And as it relates to third-degree criminal sexual conduct based on force and coercion, it's clear, based on what the court has seen, that there was force involved in this case. And the third-degree criminal sexual conduct based on mentally incapable, consent is not a defense to that, because the fact of the matter is you cannot consent if you're so drunk. Now, we have testimony from...
Wait a minute. Back up.
You cannot consent... Well, let me back up. Okay. Consent, there's not a defense of consent to criminal sexual conduct in the third degree if the consent could not be given because the victim was too drunk to give the consent. And when
Stop, you're confusing me. I want to be very clear on what your argument is.
okay, for criminal sexual conduct.
Wait,
Okay.
let me tell you
Okay.
what I've got, and then
Okay.
you correct me.
Okay.
Are you telling me that I have to look to the victim's state of mind to decide whether there was consent or not, and she couldn't have consented no matter what because she was too drunk to give consent?
No, there's two separate charges. One charge, the defense of consent goes to force and coercion. Okay? That is a legitimate, that's a defense to that charge. What I'm telling the court, according to the case law, consent is not a defense based on CSC 3 if you're proceeding under the theory of mentally incapable. They're two separate charges. You understand what I'm saying? For the mentally incapable, if the victim was so drunk, and then the relevant portion of that charge is that the defendant knew or should have known that the complainant was mentally incapable at the time of the alleged act. Yeah.
Address this additional question
Yeah.
for me. What if the defendant is too drunk? Does that fix in there?
That's a question. That will be a question of fact for the trier of fact, because once again, his state of mind that the defendant knew or should have known that the complainant was mentally incapable at the time of the alleged act. But if you credit the testimony of Officer Johnson, and I believe that there are reasons not to credit exactly everything he says, but he said to him that he didn't believe the defendant was intoxicated. So once again, based on that question of fact, if to the defendant Johnson, he didn't see him as intoxicated, he didn't think he should have arrested him for drunk driving, he just simply gave him a ride home because it was dangerous according to Johnson's testimony, the defendant cannot now claim, I was so drunk that I could not assess assess the complainant in her state of mind. So when you focus on criminal sexual conduct in the third degree, mentally incapable based on the complainant's intoxication, the issue is that the defendant knew or should have known that the complainant was mentally incapable due to her intoxication at the time. There is ample testimony on the record, and you heard testimony from Ms. Dowdell, that out of a scale of 1 to 10, she was an 11. Okay, there was testimony that she was in the room, they couldn't get any information out of her for a long time because she couldn't get the numbers out and things of that nature, and based on the testimony of, and then Officer Johnson, although he indicated to him that she didn't seem that intoxicated, he said she was intoxicated, she was too intoxicated to drive, but it is the defendant's assessment of her level of intoxication which we must focus on here, which is, at this point, a question of fact for the trier of fact. And lastly, when we talk about criminal conduct in the second degree, we're talking about a touching, a sexual touching of the genital area. And in this case, it could be over clothing, which we have testimony about that in this case, done for a sexual purpose. And for this child, that there has to be force or coercion, which there's been testimony about, and the court has seen the video, and that the victim was mentally incapable at the time, and there was personal injury. And personal injury has been described as bodily injury according to the statute. And in this case, there was bodily injury. The court indicated. The court heard the testimony of Nurse Most, who indicated all the bruises and abrasions. And according to the case law, permanent personal injury and bodily injury does not have to be permanent injury, because the statute talks about bodily injury, and then it also talks about mental anguish. And also, if you look to the criminal jury instructions, they talk about being crying and hysterical as amounting to mental anguish under the statute. And for those reasons, Your Honor, based on the testimony, and if the court would like the case law as it relates to the injury suffered must not be permanently or substantial, and they're talking about bodily injuries, and those are People versus Cry, K-R-A-A-I, 92 Mich. App 398. And People versus Mackle versus 241 Mich. App 583. So based on all the testimony, I believe the elements, I have presented evidence on each and every element of the case, and I ask the court to define this defendant over as charged.
Ms. Lindsay?
Yes.
Wait a minute.
Yes.
I have a question.
Yes. Can I just
In
have a
your
moment?
argument-
Can I just have a moment, Judge?
Sure.
Yes, Your Honor.
In your argument about the inclusion of bodily injury,
So he did, in fact, cause those injuries. You have any other questions, Your
no,
Honor?
ma'am, that was my question. Mr.
Your,
Manley?
Your Honor, I'm sorry, but can we take a quick
Sure.
break?
Mr. Muscat, do you have the cases she cited? Because my court, no, leave me on the record. My court reporter is going to want the spelling of Old Plant and quite a few of the other ones.
One of our assistants is going to do that.
Okay, thank you.
I personally don't understand your question.
No. Deputy, do we have a problem? Okay, let's go back on the record then. Okay, we're back on the record in the Cleaves matter 16T 538 FY. Mr. Manley, you may begin your argument, sir.
Thank you, Judge. I stand here today and I'm frightened. I stand here today and I'm shaken. I stand here today and I have because of those things, and I'm not easily moved. I'm a guy that is pretty steadfast. I'm not easily this evidentiary standard or that evidentiary standard. The fact of the matter is, Your Honor, this didn't happen the way it's put forward. It's untrue. It's not true. And the reason that they have you sitting up there, one of the many, is to judge credibility. The reason that the prosecutor stands and talks about the different levels of proof is because they know that. They know that they're trying to make leaps and bounds. They're trying to make assumptions. They're trying to throw things against the wall and hoping if we throw a mass that something will stick. That somehow, if we paint with that very broad brush, or if we say it's just a low bar, that somehow that automatically requires that very low bar to be jumped over. It's not true. And it's unfortunate. And the thing, when I said the making of a murderer, making of a rapist, you look at the things that were not turned over. You look at the desire to convict or the desire to move forward in the case against the actions. And you look and you see that things weren't turned over that were exculpatory in terms of things that would have given this court a better chance to judge credibility. They were held back, and I understand that the prosecutor can put their case in, but their job is justice. Their job is to do the right thing. Their job is to put all of this in front of the court. I had to call Detective Sergeant Johnson. I had to call him. That speaks volumes. They weren't going to put in the phone records. They weren't going to do any of that. You look at that and you see that the lines are blurred from doing justice to doing the right thing, seeking conviction at the expense of honor and duty. And we've seen that. You look at this case and it doesn't add up. And there's certain seminal moments in life when you're listening to people. And People versus King, which they're well aware of, allows you to judge the credibility of the witnesses. There is no he said, she said in this case. Mr. Cleaves has not testified. That's a canard. That's a red herring. There's a she said, she said, she said, and she said. And if there's anything that came out that was negative to the script, I don't remember. I don't remember. I don't remember. And it was clearly coached because you could see it. I mean, this is why we have a live jurist, an experienced judge, to look. The court was even moved itself to make inquiry of why are you looking over here? Why do you keep looking over here? There were things that were irrefutable and argued about. Is that you in the car? Long pause, argumentative. Long pause, argumentative with me. What might have been my arm? You can assume it's me. But those are things, when you know you're telling the truth, you don't have to say, you can assume it's me. That's me. That's my arm. But anything that went against the script, I didn't remember. This court has to make a determination on credibility, Judge, on credibility here. It's been before. And like I said, there's no jury question here. And again, it's a misstatement of the law to say with force or coercion there's no consent. The Abdullah case that counsel cited is a case where someone was robbed and sexually assaulted at gunpoint by multiple actors. It has nothing to do with this case. Again, we get all this jump up, well, I'm going to cite this case, cite that case, cite this case. And when you stop, most of them are unpublished, which are non-precedential. Most of them have fact scenarios that have nothing to do with this case. They do that because they're hoping that by throwing all of this around, that she can't consent. Well, that's not utter nonsense. Utter and absolute nonsense. You look at this case. You look at the Whaley home. You look at where they started. The pictures and so forth. The drinking over there. Over to the bar. You ask yourself, okay, who initiated this thing here? And you see. Then they get to the bar, and there's drinking that goes on. There's invitations to Mr. Cleaves. Not vice versa. Mr. Cleaves did not invite her. She invited Mr. Cleaves. You get over there, and there's shots and so forth. She leaves voluntarily with Mr. Cleaves. She couldn't even get out, and going again to these investigative subpoenas and my argument of misconduct to dismiss the case entirely, they know it's untrue. That is what scares an advocate. That's what scares an honest lawyer. They stopped the investigative subpoena. They stopped it when they knew that she was under oath and she deviated from the script. Unheard of. They stopped it. They don't want the truth. They want a scalp. They don't want, the truth has long since fled the building. The truth, the search for truth has long since fled the building. And they forced a shifting of the burden to the defense to call witnesses. They've forced a shifting of the burden to the defense to provide phone records. These are things, when you take that oath as representing the people of the state of Michigan, these are things that you have to do. You have to do these things. It's not about, I convicted this person, I convicted this person, oh my God, I'm going to get an award because I convicted Mateen Cleaves. That is so wrong on so many levels. And you see this. They gloss right over. They don't question the fact. They put in, well, Mr. Cleaves wouldn't let you have a phone charger or a phone. And then when I asked her, I read right from Naring's report, he said he didn't have one. Well, when you present that kind of evidence, one is nefarious and one is, I don't have one. They allowed, in fact, they elicited testimony that would lead one to believe that this was a little mom and pop gas station, liquor store. Like maybe had a bathroom, had one of those little latches on it. My God, it's an expressway type superstore with a 24-hour McDonald's, a 24-hour grocery, bathrooms that are massive. And when she says she didn't see the door, the clerk says, you would walk right into the door. She says she doesn't remember, but yet under cross-examination, she remembers that it was fun to play with the moonroof. They didn't call her boyfriend to the stand. They know why. Because there was no plan to go to Warwick Hills. That was nonsense that was planted the next day, Judge. She, under oath, she said, well, I really don't remember. And even the best they could get was a combination of memories. She knew exactly what she did. She left voluntarily, and she said goodbye to Mr. Bryant. Mr. Bryant, and they know this, and it goes to, again, the way they presented this case, he never went to look for his girlfriend. She testified that he'd been living together for 4.5 years. If in fact she was missing, they would have presented calls to the police. He would have gone out. The story's not true. That's why. The story's not true. They want to make her an 11. But Steve Klein, who's got no dog in the fight, at the gas station, indicates that he was there. He let her use the phone. Didn't appear to be drunk. Didn't appear to be stumbling. Nothing unusual there, Judge. Nothing unusual. Cameras everywhere in that store, and it's a big store. She remembers everything except the things that hurt the case. She remembers all the details except the 12 gas pumps, the cameras. She did remember the 3 stalls. Fact of the matter is, Judge, I'm forced here, and I'm doing it, and I can do it. There's no probable cause. I'll prove beyond a reasonable doubt it didn't happen the way they say it happened. It didn't happen. She was calling, Judge, for an alibi to her boyfriend. There was no call for help. If there was a call for help, or I wanted to go home, or any of that nature, just stand there. Have the clerk call. There was nothing of that nature. Nothing whatsoever. The court viewed the arrival at the motel. Now this is after she says that she was in distress. This is after she said that I was trying to call my boyfriend. This is after the prosecution wants to believe that, one, she's determined that she's not going where she said she was. Two, that she's worried that she doesn't have a phone. Three, that she's somehow worried no one knows where she's at. And yet she's sitting there. And it's so indicative of the lack of credibility, so an avalanche. And I don't know why she's doing it. I don't know if it's because she wants to have an excuse for her boyfriend. I don't know if it's to make up for something to her mom. I don't know if it's for money. I don't know. What I do know is that all of the things about assault came after. Sergeant Johnson was right on the scenes. And if you look at her, when she came up at the motel, my God, you've seen it. She's sitting there. And if you take her words, you can assume it's her. Well, if I'm assuming it's her, then she's fixing her hair, and she wanted to argue about whether she was fixing makeup, if that was lipstick or makeup. But clearly, they're doing something in a manner to make herself look better. She's standing there. Mr. Cleaves, if Mr. Cleaves is somehow, in some malicious way, that he's now taking her away from where she's supposed to be. Think about this for credibility purposes. Why in the world would Mr. Cleaves, who's well known, who's now taking somebody away from where all these people think they're supposed to go, to Warwick Hills, stopping at a place, a 24-hour place, where there's cameras, where he's well known? It defies imagination. The reason it defies imagination is because it's not true. It's not true at all, Judge. If you were, supposedly, if she wasn't on board to go with Mr. Cleaves, if somebody thought they were going to Warwick Hills, and so forth, and Mr. Cleaves had decided that he was going to deviate from the plan and just take her, why in the world would you stop, let her go and buy some juice? Buy some juice. That's consistent with the plan. It's consistent with the consent. And the idea that you can't consent, that's false as well. You certainly can consent. And they've alleged in here force or coercion in a number of these charges. So when counsel blurts out, you can't consent, and it's in the mind, it's not true. It's not true. But you get there, and you see that you get in the car. Nobody goes to Warwick. The reason they didn't put anybody up is because nobody goes to Warwick. You know why nobody went to Warwick? Because nobody was ever going to Warwick.
Wouldn't it have been closed?
It would have been closed. But nobody was going to Warwick. It's a canard. It's another untruth. It's another brick in the wall that scares when people are sitting here going and having somebody come up and say, well, it's only probable cause. Well, if probable cause can ruin somebody's life, probable cause is a standard. The reason that we have it is to determine that something is more probable and reasonable. And I don't have to sit here and, like I said, say, oh, it's just probable cause. That's like saying, well, you died just because you had a small infection. No. You're still dead. But it doesn't make sense. Look at the credibility. They bring in, and you look at just how this case was put together. They bring in an expert, Nurse Most, and she's supposed to testify, and I see on the screen a sheet comes up with all of these alleged bruises and wounds, and I'm going, oh my God, it looks like a trauma patient. And then I said, well, you know, in your expert opinion, the course of treatment for these injuries, I said, well, what were they? Well, there was a scrape on the knee, and, well, what would you do? I'd wash it and put some triple ointment. I'm guessing she meant like something like Neosporin. So my point being, the exaggeration, the untruths that have been put together. They get over there. The woman testifies. Now, clearly she's trying to stay on script because she knows that if she's not on script, they'll cut it off again. That's why she's looking over there. And she's already had the experience of going off script once. She knows that she's got to stay with that script. She goes in, and this thing about going home, I want to go home. She said, I want to go home, you've got a boyfriend, or I've got a boyfriend, or you've got a wife. That sounds like almost classic banter in something. In something, you know, whether it be just banter. And then she says, after that, Mr. Cleaves kissed her, and she kissed Mr. Cleaves back. She kissed Mr. Cleaves back. The idea that there's somehow that she was just laying there taking some type of sexual abuse defies imagination. You would have far more in terms of, suppose that she pushes Mr. Cleaves off twice. Twice. There's nothing to support that. There's nothing to support that. This lady comes out and she says to the officer, I went out to get some air. They say that there's no throw up, but they've got a witness that says there is. I mean, this is not a game with somebody's life. This is somebody's life. This is not gamesmanship. I got you. I sandbag you, so you have to call a witness so then I can cross-examine them with statements that I haven't shown them. That's not right. That's not right. Just to ruin somebody when they know. They absolutely know that it couldn't have happened the way they say it happened. It just couldn't have happened this way. There's nothing to support it. Everything that goes, you look at all the I don't remembers, and you place them where answers should be. And then you look at where answers are, and it's always the negative. She remembers the things that fit the narrative. And she doesn't remember anything else. Anything that might be off of script, she conveniently forgets. And it was so clear that somebody, whoever talked to her, whoever prepped her, said, if you're not sure, or if they ask you this, say you don't remember. And if you think that I'm just being paranoid and I'm talking about defense lawyers or if somebody's going to ask you a question, I read it into the record that the detective, at the time of one of the initial interviews, said that we've got to do this, this, and this because the defense lawyer is going to ask these questions. The detective indicated, but he's one of the good detectives because he stayed with the script. The bad detectives got to stay outside and not get their interviews or anything else. Judge, it has to be reasonable and probable that this happened. You look at the video and you see she didn't run out. You see that Mr. Cleaves was trying, and everybody said, you know, you get to see it. In terms of, the phrase today was manhandled and so forth. I'm stating not so much. I'm stating someone who was trying to help someone get back into the room and get their clothes on. When you look back on that, and the alternative to this is, what was Mr. Cleaves supposed to do at that point? And understand here, Judge, Mr. Cleaves, there's a situation, if Mr. Cleaves was there, and clearly with the DNA and so forth, that's with his wife, okay? I mean, that is something that he would have to take up with his wife. If he committed some type of marital infidelity, or if he misbehaved maritally, that's a private matter. But to somehow indicate that and make it criminal, the court looked at that. Mr. Cleaves, a former professional athlete, if he was trying to grab this woman or to hurt this woman in a sexual manner to bring her back in, it would be shown. What you see is Mr. Cleaves trying to get this woman back in. What is he supposed to do? Let her run out naked? Or she gets hit by a car? Last person on the videos to be seen with her is Mateen Cleaves. There is no secret. Mateen Cleaves would be on the camera at the gas station, which the police didn't produce. They could have had it. Mateen Cleaves is on the motel where the lady's fixing her hair. People don't bring up the fact that Pat Beal, but they have this statement. The woman asked, and she heard from Pat Beal, which room is it, Mateen? And she's going into it. Don't you think that if truth, justice, and the American way were what we were supposed to do, we'd have heard something about that? Or is it conviction, high profile, run for new office? That's not the right standard. That's not the right standard, Judge, by any stretch of the imagination. I look at the charges here. Unlawful imprisonment. Really? The woman gets out from a fellow who played at the highest level. I beg to differ. If he in fact wanted to imprison her, she'd still be in prison. There was no, if anything, you can't have it both ways. He imprisons her, but by the same token, he brings her in on all these occasions. What you can see, and this is where the court has to judge the credibility and common sense. There's no way in the world. Each time she comes out, she's more clothed. And clearly, Colleen Dowdell said she had a hard time clothing and getting Vendel dressed. One can assume, for arguendo, that Mr. Cleaves had the same problem. You're going to dress her more, sexually assault her, and send her out? Makes no sense whatsoever, Judge. This case does not rise to the level of the case. Element by element, and I'll go through the elements, but the fact of the matter is it's not credible. It doesn't add up. It doesn't make sense. What makes sense, and I don't know why, but regret is not rape. Maybe after she puked, those shots hit her. Maybe she thought, oh my God, my boyfriend's going to find out. Oh my God, they called my mother. What is she going to think? I'm embarrassed, I'm humiliated. What are they going to do at my job? What are they going to do if they find out I went off and they think I'm of loose morals? Are they going to fire me? I don't know. But those are all scenarios that certainly fit this fact pattern far better than Mr. Cleaves taking this woman, forcing her to submit to some sexual assault. And I listen and I'm thinking, if you believe that Mr. Cleaves is of such character that he's going to sexually assault this woman, but he waits until the second time she runs out, when she's more clothed, and even though he's going to commit this atrocious assault, he barely moves her underwear over to attempt to do this assault. Makes no sense. It makes no sense because it's not true. It makes no sense whatsoever. The woman doesn't know, and what she does know, she doesn't want to tell, and she's locked herself into a story. And then you see Johnson, poor Johnson. He comes there, he gets the story, and this is important because this is a chance to get the story before we've had mom arrives on the scene or boyfriend's arrived on the scene, where you have to come up with, why are you here? What possibly possessed you to do this? Why didn't you go home? Why didn't you go home? Well, they knew. They knew. And there's no suggestion that the idea that she's comatose or that she's mentally incapable, and so again, a canard, something that's just thrown up there. That she, well, you know, and you say it fast and you hope somebody believes it. But the fact of the matter is, if you're so drunk that you don't know what you're doing, then you're sure able to spit those phone numbers out. And then you look at this, and this is where they can't do it. It's akin to the Karate Kid, where you got that train technique, and they know it. It's not 13 minutes. It's not 13 minutes. She says after the second run out, she runs in, and almost immediately she's assaulted, and then she runs out. And when you look at she runs out almost immediately upon the assault. She pushes Mr. Cleaves and runs out. Now we know, because people put in still pictures, that Colleen Dowdell is standing out there. So we know the 911 calls are at 201, 202. We know that. Judge can see that, okay? So if you come out at that point, and Mr. Cleaves is calling your boyfriend at 1:56 and texting your boyfriend at 1:56, before that, he is trying to use the phone for somebody to come pick her up. The people know this. They know that Brooke Adams got calls around 2 o'clock in the morning. One of the more ludicrous things I've heard in this case is someone saying, well, he knew it wasn't going well, so he's going to call and get his alibi. Are you kidding me? I'm going to call somebody I just tried to rape's boyfriend and say, hey, it's not going well, but I'm over here just in case. Are you still up? The audacity to make that argument is admirable. The ethics of it, less so. It couldn't have happened that way. It just could not have happened that way. You look at this and they say, and even she says, she never says that there was force or coercion used. In fact, when she told Narian, I never told him no, and it's not like I, told you, just get away from me. I mean, if you're going to hang your hat on force or coercion, and you're going to misstate the law on things that force or coercion are used for, in the cases they cite, and if Abdullah is not a case that involves somebody that was anally attacked and sodomized with a gun and multiple people, and what that has to do with this case is nothing. All the cases that have been cited have nothing. It's very tangential. They're what I call head note sites. They read a head note and they read it in, and they hope that nobody will go back and read. There's a jury instruction on consent. And there's nothing that would suggest whatsoever, again, that this woman was in any way, shape, or form comatose, where she was just laying there and couldn't. My God, they describe her as coming out of the room. And if in fact she had just been assaulted, don't you think that if it was true, he just assaulted me, Mateen Cleaves raped me, he did this. when you look at the cases and you look at the testimony, everybody looks at it differently. Things jump out off the page differently at different people. But if somebody had been on top of you, sexually assaulting you in your underwear and so forth, and you go back and you say, by the way, can I still have that bra? That's troubling to me. Not troubling if you are in fact not telling the truth, because it makes sense. But it makes absolutely no sense if in fact you were sexually assaulted. I mean, do you want the panties too? It just makes no sense, Judge. It makes no sense. You go through here, assault with intent to commit sexual penetration. I've talked about unlawful imprisonment. At no point in time was she unlawfully imprisoned. I asked at the court, see, that's the People versus King. That's my lifesaver in this case, that I have a jurist that in a law empowers a judge to look at the actual body language, the actual testimony as it's given. Because if not, we could just submit a transcript and then credibility would be out the window. We wouldn't have to deal with credibility. We wouldn't have to deal with, why you keep looking over there? Why they're not giving the answers? Talk to Mr. Manley. Because if it's just a transcript, we don't have that. We don't have the ability to weigh the testimony. And like I said, there is no he said, she said. There is no Mr. Cleaves saying, I did this. There's this woman giving multiple stories against herself. I don't remember. I kissed him back. I never told him no. And then the last story that's most ludicrous of all, that he moved the underwear on that somehow got on after she ran out the first time. So he supposedly was unlawfully imprisoning, redressing her, and just decides in the middle of all that to sexually assault her. And if you can't, the phone records, while 911's being called, as he's coming out, there's people around. He motions to one Pat Beal. He motions. They have the statement. And this is just atrocious. They know that Pat Beal said that Mr. Cleaves waved over to him, and he didn't know if he wanted him to come over and help with her or whatever. They know this. This is their oath to do the right thing. They know this. And yet they keep it over here. You know, I don't say Duke Lacrosse, Virginia case lightly. You know, Wayne County's got prosecutors, many, many good people, obviously. But this is the kind of case where they've lost their bearing. This is the kind of case where doing the right thing has taken a secondary position. They know this stuff. It's not a matter about, we'll just put her up or we'll put somebody up and just hit the target probable cause, and then we'll have him in a position that Mr. Cleaves is awaiting trial. We'll have him behind the 8 ball, and it gives us far more maneuverability. Let's just go for the lowest common denominator. Let's just hit that very low bar, and hopefully we'll get it over, and then we hold the cards. Law is not set up that way. They still have to come in front of you or another judge, and you have to determine what happened. You have to determine that it's more probable than not, it's reasonably believed that a crime was committed. It's not suspicion. It's not just because somebody says it. It's more probable than not. How would you believe it's more probable than not based on, I don't remember, they told me, it's a mixture of these things, I did this, I kissed him back, there's no physical evidence to support any manifestation. When you look at the evidence that was brought forth by the forensic nurse, This is her second time she's testified in court. She had a bias. She felt that Officer Ogle did not treat her appropriately. She felt that way. That wasn't turned over to us. That wasn't, again, when you see how this case was put together, they called a so-called expert witness that they knew had made a complaint to the police department against one of the first responders. One of the first responders, again, that was not called. In order to believe that this actually happened in the manner that you do, you have to believe that four, not one, 4 sworn police officers saw something there, turned their back, did not do an investigation, and just let Mr. Cleaves go. You have to believe that there was something that Sergeant Johnson missed and just let him go. And they keep saying, well, details. There were no details. Colleen Dowdell said that there was a woman running out of the room. That's what Johnson was told. That's what Johnson was told. 911 call said someone out of the, that's what Johnson was told. There was no plot. There was no hidden agenda. There was nothing to suggest that Mr. Cleaves somehow got away with one here, Judge. There's nothing like that. Judge, the fact of the matter is, you look at this, and you have to take it, and you say, okay, he touched me, he pulled my underwear aside, he pulled me back into the room. And then you log it up against somebody who consensually was in the room, got sick, panicked, ran out for whatever reason, and Mr. Cleaves attempted to dress her. And the first person of authority to be there was Officer Sergeant Johnson, along with the 3 other potential people. And it's significant that when she said, and this is before she's had a chance to come forward and put something together, Dowdell had to coach it out of her. We had sex. Not he raped me. And I'm not a woman, and I know that people would say things differently, but we had sex based on, I kissed him back, I never told him no, all of these things. You look at it, there's no evidence whatsoever, Judge. And when you put it into that time frame of when she said this happened, it's impossible. It's absolutely impossible. Again, it's not 13 minutes. It's a very small window. She says, Mr. Cleaves was on top of me, he pulled my underwear to the side, and he attempted to penetrate me. At that point, I pushed him out and ran outside. At that point, you can see Colleen Dowdell out there in the still picture. So you timed it at 2:01. You timed it at 2:01. So you know. So it wasn't 13 minutes earlier. It wasn't that he raped her and held her in. Her own testimony, which is clearly designed for her own testimony. But what she didn't count on is that the film that they think is so powerful for them actually does the right thing and shows that Mr. Cleaves was trying to get a hold of the same people, you know, that she wanted other people to call. She's telling, Cleaves is calling the boyfriend. And that's who she wants the other people to call. He's calling the boyfriend. There's no rape here, Judge. There's no assault here. There is probably a scared, or God knows. I don't know. I don't know her. I don't know if it's malice. I don't know if she's embarrassed. I don't know. But there's not enough on this record to send this case to trial. Not only is there not probable cause that's been shown, I've defeated probable cause. by any reasonable doubt, I've defeated probable cause, which is unusual in this kind of case because normally the defense does not put on a case at this time. And like I said, there's no evidence whatsoever on each and every element that even if you say that she touched, the arm, and you say, so many words have been used about grabbed and pulled and so forth, you've seen it. You know that it looks like he's trying to help her back into the room. You know that. And she comes out, and what shows that is she comes out more dressed every single time. And once she's dressed, that's done. And that shows that Mr. Cleaves could not have, number one, assaulted this woman. Number two, that once she's dressed, there's no imprisonment whatsoever. She's down trying to get, the calls made. And the mouthing of help and so forth, suspiciously that none of that's ever mentioned to Sergeant Johnson, the one person that actually is charged by law in order to help her. The story kind of builds on its own, and it clearly, there's no winners in this situation. But at this point in time, there's no probable cause, and Mr. Cleaves should not be losing any more for these unfounded allegations, Judge. There's no force or coercion used to, force a sex act in any of these charges. There's no false imprisonment, and there's certainly nothing that suggests that this woman could give the phone numbers of not one person but two, was so out of it that she just had to lay there and take it. I'm asking that the court use its power, judge the credibility, but even more so, judge the facts, because what they're using is that time frame, and it couldn't have happened. And I ask that the court dismiss all five charges. Thank you.
Counsel ignores the testimony of...
Sorry, I didn't hear your first couple words.
Counsel ignores the testimony of Ms. Dowdell, who indicated that the witness came out yelling, help me, call 911. That is the testimony of Ms. Dowdell. She indicated that the woman yelled that as she ran out the room. Now, why is the complainant saying that? And counsel argues that this was all because the complainant wanted to be at that motel with the defendant. But if she wanted to be with the defendant so bad, why did she run out the room desperately trying to get away from the defendant? Why did she lunge, and the court saw the video, into the doorway of Colleen Dowdell? If the defendant was simply concerned about her being outside naked when she was lunging into the room of Ms. Dowdell, how come he simply did not let her go into that room? Everything counsel has argued goes to questions of fact. Now, what is interesting to me, Your Honor, is one of the hallmarks of credibility is if a person tries to make someone else look worse than they do and try to make themselves look better. In this case, the victim, if she were lying, if she was making this up, she simply could have said, point blank, I told the defendant no. If she was lying, and if she wanted to put a case on the defendant for whatever reasons they saying to protect her reputation with her family, she would have done a better job of it. She would have said straight out, he got me in that room, I told him no. She would have said, I never kissed him back. She would have said, and remember, when she went to the hospital, she told the nurse, I kissed him back. If she was simply trying to make up a story on the defendant and lie, she would have simply said at the hospital, I told him no. I told him no repeatedly. I did not kiss him back. He forced himself on me. She didn't do that. She said things that made herself look bad. That is a hallmark of credibility. She's not trying to make or sell her story. She's telling what happened as she remembered it. One of the other things counsel keeps arguing is there's no other witnesses not corroborated. According to the criminal jury instructions and the law, the testimony of the victim need not be corroborated. Now, let's talk at length a little bit about Johnson and his testimony. Counsel wants to conflate this whole thing about 4 police officers having to get together to help Mr. Cleaves. That's not the testimony. The testimony is, and the video shows, that the only 2 police officers who went down to the area that the complainant was in were Ogle and Johnson. As a matter of fact, Johnson said that the female officer, Colette Newman, never had contact with the complainant at all. So she doesn't even factor into the equation, because when he comes back, according to Johnson, he doesn't even remember what he told Colleen Newman, the female at the scene, about what happened at the room. And the other thing is, he never told Officer Badal, there was no testimony that he told Officer Badal about what happened down at the room with his contact with the complainant. So you take those 2 officers out the mix. The only 2 officers' conduct that we have to focus on here are the conduct of Johnson and Ogle, because the female officer at the scene never had contact with the victim. She was not informed that the victim was injured. She was not informed that the victim supposedly said what she said to Johnson. So once again, you have a classic credibility contest between Officer Johnson and the complainant as opposed to what they said in the room. And furthermore, Johnson, supposedly he's so professional, there was a way for us to know exactly what was said. The simple fact of the matter is, he could have taken her to the scout car and could have recorded what was said, but he didn't. Furthermore, I'd assert to the court, if the court wishes, the court can look at the squad car video or the cruiser video, I'm not going to say scout car video at this time, that contradicts what Johnson said on the stand. Johnson said, well, finally he backed off and he said he doesn't remember whether there was any evasive maneuvers on the part of the defendant. The video shows, in fact, that once Officer Ogle pulled in front of the defendant maneuvered around and then drove a little bit, and then he finally stopped. The other thing that's interesting about the video is Officer Ogle indicated that he testified that...
Wait a minute.
Excuse me, Officer Johnson, I'm sorry.
I never heard
No, I'm sorry, Officer Johnson. Officer Johnson testified that he took this call seriously from the start, and he tried to be focused and do things to minimize distractions. The court listens to or would look at exhibit number 1. The court will see that he had his music blaring as he approached the scene. He never turned the music off. That's why you can't barely hear what the defendant Cleaves says, because his music is blaring the whole time. He doesn't even take this call seriously enough to turn down the music playing in his squad car in order for the statements being made by the people on the scene to be heard and properly recorded. As it relates to making a final determination as to credibility, that is not this court's function. This court's function is to assess whether each and every element, there has been testimony as it relates to that, and resolve any issues of credibility, final issues of credibility. That goes to the ultimate fact finder. The victim did say certain things happened. She couldn't remember certain things. As it relates to that, the court has heard about her level of intoxication. She did not try to make the defendant worse than what happened on the scene. She could have very easily said, if she was going to make up a story to satisfy her family or to satisfy her employer. She could have said different things about how she got into that room. She could have said he forced me into the room. She could have specifically said he undressed me, I didn't undress myself. There are a whole lot of things that the complainant could have said if she was making it up to make the defendant, to make this a slam dunk. She could have straight out said, I told him no. He threatened me and said if I didn't comply, he would beat me, but she didn't. That would have straight out if she was lying. I mean, the whole lie story doesn't make sense. I'm going to tell a lie on the defendant, but I'm not going to tell a convincing lie? That doesn't make sense, Your Honor. Based on everything that the court has seen, and let me just pull back for a minute and address counsel's supposed Brady arguments and supposedly what I know and what I don't know and what the evidence other witnesses are going to show. You don't know.
Let me stop you just a second.
Okay.
He made those arguments. The court didn't really listen to them because I never received any evidence as to those arguments.
Okay, well,
I happen to be the type of person, if you tell me something more than once, I might believe it more. So if you're going to tell me something that didn't come into evidence, I'm going to ask you not to.
I'm not. All I'm going to say is all his arguments about what other witnesses are going to say, those are just allegations. Because in terms of, you can only base the testimony on what you have here. And what other witnesses may or may not have said, you can't consider, because that's not what you're supposed to do. As it relates to the issues of what the victim could have done to lessen the danger to herself, the case law is clear, and I cited to the court the case law. She doesn't have to do anything. But the fact of the matter is, she did run out. She was yelling for help. The court saw her face. She did look scared. Colleen Dardell said she looked very scared when she saw her, and Colleen Dardell indicated that she said that she took it, she laid there because she couldn't fight him off. That was the testimony that she gave.
Are you?
I'm done.
Okay. It is 5-3. This court wants the opportunity. I have notes coming out my ears. This court wants to take the time to review all those notes, but I want an opinion from the lawyers as to one question. And I'm not quite sure how I want to word it. Define, Ms. Lindsay, a question of fact for the jury. Define a question of fact for the jury.
I don't understand the court's question.
If you were in law school, you'd understand it. Define for me a question of law for, a question of fact for the jury.
I'm not trying to, I really don't understand what you're...
Okay, that's fine.
I really don't, Judge.
Define a question of fact for the jury.
Something that would be at issue that's been presented at this stage of the proceeding, not questions between prosecutorial witnesses amongst themselves. In other words, if you have Team A and they all give different stories, that's not a question of fact for the jury because they're not Team B, which is Mateen Cleaves over here. If we had put forth Mr. Cleaves up there to make a statement.
That's not what I'm talking about, Mr. Manley. I know where you're going. That's not what I'm talking about. I want you to, no, I want you to define for me a question of fact that this judge would have to find to set this over for the jury.
You're asking me?
Yes.
Something that Mr. Cleaves forced this woman, one of the elements in all of these is that there was force coercion used to complete a sexual act.
And if I find that's questionable, I must send it over for the jury. Is that what you're telling me?
If you find it's a question, then you could send it over for the jury. My position is that there's no evidence whatsoever of that.
Okay. Ms. Lindsay, ma'am, you started to answer my question and I stopped you.
Okay. a question of fact, as far as I'm concerned, is resolving any conflicts at all in the testimony. I don't believe it is the function, according to the case law, for the court to resolve conflicts. Like, if there's a simple, I can't state it any simpler, more simple than what the case law says. If there's something on the record to support an element, and there's also something to negate an element, that is, according to the case law, a classic question of fact. So, and I cited to the court, and I can go ahead and I just, for the record, put on the record all the cases that indicate that people, and I can actually give the court the case.
If you just give my court recorder the spelling, just give her a list of the cases with the spelling.
Okay. You want me to do it now or later?
Yes, please.
Okay.
Okay. We are adjourned. I'm going to tell you folks, it's going to take me a half an hour at least to look through all my notes and try to come to a formulation of whether I believe there's probable cause or not.
Does the court need any of the exhibits?
If I have, yes, I do. I need the lab reports, please. You took those back.
We have the exhibit book. If you could, do you just
I just want the lab reports, please, ma'am.
Okay.
And Judge, and you understand my position is because of the timeline that there is no question of fact.
Yeah, I understand that.
May I play something on the record, Judge? I'm going to, I have prepared discs of the exhibits that have been admitted, as well as Defense A and Defense B. And I have given a copy, I made a copy for the police, I gave Detective Nguyen a copy. I have a copy for defense counsel that I'm handing them right now. I have a copy that I'll give to your court, I'm not sure.
My court recorder.
Court recorder, okay.
Although I have to tell you, if I think I want to view a video again, I will be coming out to the courtroom.
Oh, yeah, that's fine with me. This is just for the record, so the court files a copy of all the exhibits.
The court doesn't file those, sir. In this county, we don't file the exhibits.
And we don't either, Judge. It's just a disc that has the exhibits, and for the record, I named them with their exhibit numbers, so it would be easy for anyone to follow.
Okay, we're off the record. I'll try to do it in a half hour. It may take me a little longer.
Here's your copy.
My copy?
I should put on the record on you.
Thank you.
Lieutenant Rule, I need you.
Oh, Mr. Brown.
Take that.